Why were you late for court?
I was sorry, I was walking over from the parking.
All right, you just never seem to time things well.
I was trying to get close to parking spot today,
Yes,
so
but you had all day to get a close parking space. You know what? If you're going to be late in life, you're going to miss out on things. You understand? Because you were late today, you know what I could do? Have the deputy take you into custody and take you to jail. And then you know what happened with your vehicle? Your vehicle would probably be towed wherever it is. You understand? Do not be late in your life, not just for court, but for anything, because people are depending on you to show up on time when you say you're going to be on time. You understand?
maybe excuse Judge, I have a in
Yes.
the morning.
All right. See you in the morning.
All right, see that.
All right. And could I see Eric Gonzalez Lopez? Where is Mr.? All right, Eric Gonzalez Lopez and Fräulein Guzman Velasquez. Where is he? Well, we'll take up your matter, Kathy.
Thank you.
And which one is your client?
Eric Gonzalez Lopez.
All right, Mr. Gonzalez Lopez. Yes. All right, we're going to go on the record. And the reason why we're going to go on the record for this is because of the new evidence that may or may not be available. Court is calling 2022 CR 10958A, State of Texas versus Eric Gonzalez Lopez. Could I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
Kathy Compton for Mr. Gonzalez Lopez.
And are you Mr. Gonzalez Lopez?
Yes.
All right. And if the interpreter, if you could raise your right hand for me, do you solemnly swear or affirm the testimony? I'm sorry. Do you solemnly swear or affirm you will faithfully translate from English into Spanish and Spanish into English? So help you God.
I do, Your Honor.
All right. You can lower your hand if you'll state your name for the record.
Arlene Abrams, license number 2081.
All right. We were scheduled for a jury trial. However, there's been new evidence that there is no way the state would have known or the defense would have known. Is that correct for both parties?
Yes, Your Honor, we found out about it, or I really found out about it along with the defense yesterday.
And I think the scope of what we needed to both see was greater than what either one of us anticipated. So I would agree with that.
All right. So how much time are you all asking for? I want to make sure that both parties have the information that they're looking for.
So Judge, right now, we sent an email out on this case to our investigator. The jail said that they would compile the list of visits concerning Mr. Gonzalez Lopez. And I believe those are ready to be picked up. We just haven't had the ability really right today to go do that. So I'm assuming that those are going to be uploaded relatively shortly and we can provide that to defense via e-discovery.
All right. And the visits, I'm assuming were done by video
Yes, Judge, that's my understanding.
and nobody knows how long those visits took place, correct?
No, Judge.
Do we have any idea or approximation of how many videos?
So in speaking to the detective detective indicated to us that there was about 3 or 4 visits concerning Mr. Gonzalez Lopez. He said that they all varied in length. I don't think he ever gave a specific time as to how long each video or visit was. Did he, Kathy?
No, and I think that there were some other visits that Hank had requested too. So I think the total is going to actually be a little bit more than that. But I would think that they were probably, I mean, generally speaking, the visitations are about 45 minutes to an hour generally. My only concern is that I'm in the middle of preparing for a murder case that's, I think.
No, I will,
peer reviewed,
yes.
so-
Well, I can tell
I
both
just wanna have
parties.
time to look at everything.
No, I'm going to give you all both time to look over everything and also schedule a trial date if that's what's decided. And I'm assuming the visitations, and this is assumption on my part, took place in Spanish.
Yes.
That's
So-
the assumption.
And so
Well,
maybe
I-
there's a transcript needed, maybe not. And then there's the other issue of if he was presenting himself as an attorney, is that attorney-client privilege, even though he's not an attorney? So I think
Well, I
those
would
are
say that's a
issues.
definite no.
Yes. Yeah, no, he's not an attorney.
I would say that there
But-
is, I certainly don't think there's any privilege that would keep me from looking at things.
No,
But-
what I mean is if, and this is just me asking a question, if somebody has case law on it because new things pop up, the question is going to be, what did your client say? And whether or not this person was holding himself out as an attorney and he assumed that's his attorney, whether or not that equals attorney-client privilege. That I don't know. So people may want to start doing some research on that.
Yes, Judge.
Because I would think that if you're speaking to your attorney, you would probably tell them things. Not saying that it would be anything incriminating. We just don't know.
Well, I just want to make sure that my client's rights are protected to the absolute fullest extent of the law, as I know everybody here is interested in doing, because that is our ethical duty.
Yeah.
So I think just giving us some time to look through those things to see if they're pertinent, and we can address it together once we all have a chance to look at everything.
All right, well, off the record for a moment. This is what I think. And this is just me looking ahead. Depending on if this person presented himself as an attorney, then it may be items that the DA's office should not be looking at or looking to transcribe. So I would think it will probably be prudent on the state's part and everybody's part is if the items are obtained for the state not to look at them until it's determined if this person was saying, I'm your attorney. And then everybody look into case law on what makes attorney-client privilege. If you're dealing with someone who's not actually an attorney and you assume that they're attorney, does that still give you attorney-client privilege? And it may be something that the state should not review.
If you think that that would be the best way, just to avoid any further complications, potentially, I would be more than happy to go ahead and, well, and I think the same goes for Mr. Leal with his client. We could review those, and if we do think that there's an issue, we could certainly bring that to the attention of the court.
All right, we're
for
back
your
on,
review.
okay, all right, we're back on the record. These are my thoughts. If you all obtain all the information, and if both parties want to put it under seal, I'll review it. Of course, I'll have to have an interpreter. And if I review it, and if it appears that that person is presenting themselves as an attorney and as his attorney, and then I will let you all know, this is what has happened. This person has presented himself as his attorney, then everybody can file whatever motions they want to file as to whether or not the state should have privy to that.
I would feel much more comfortable with it going to you, even if it has to be transcribed or translated, and then you making that call, because I think that puts the responsibility, I guess,
Yeah.
that heavy burden where it needs to be as far as making any calls on who gets what.
All right. And so just so everyone know, the part that I'm going to listen to is whether or not this person meets with your client by video or in person and presents himself as his legal attorney.
Yes, Judge.
And then once that's determined, I will let you all know. He says he's his legal attorney. Then you all will do research. I will do research on whether or not that's attorney-client privilege, even though that person, we're assuming, is not an attorney.
Yes.
And Judge, what I was gonna do, because I did request the visits for Mr. Leal's client as well. I took that step. What I was gonna do is see if our investigator can go through sort of the same process that he did on this case, because my understanding is that they're supposed to be put on a flash drive,
Yes.
and then he's just gonna pick them up. So I'm gonna see, I emailed about Mr. Leal's client maybe about an hour and a half ago. So it might just be
All
easier,
right.
just to say, hey, can you just do the same thing?
All right. And Mr. Leal, could you state your name for the record, please?
Rafael Leal.
And Mr. Leal, you're representing
Juan
Caroline,
Velasquez.
and cause number 2022 CR 10958B, is that correct?
Correct.
And he's also in custody and he's in the courtroom.
Yes, Your Honor.
So it's the court's understanding then that neither defense attorneys would have an objection to the state not reviewing the videos that this person may have had with your clients, the video visitation on video or in person, that I will receive the evidence that they have. I will have an interpreter and it transcribed to see whether or not this person presented himself as the attorney of your client, Ms. Compton, and your client, Mr. Leal. And once that's determined, then you all will have to do your research. I will do my research, and it'll become a question of whether or not attorney-client privilege was established. And of course, if it was, then the state would not be entitled to this information. It would just go to the attorneys. Is there any objection to that from either defense attorney?
No objection from my side, Judge. I only have a question. Has those videos been reviewed by anybody, any detective who understands the Spanish language or anybody else in the district attorney's office? That would be my only question. Perhaps they have already reviewed those things.
May
At
I
this
speak
point.
to that, Judge?
Yes.
So my understanding is that the assigned detective to the case involving Mr. Berroca attempted to review. However, he does not consider himself to be proficient in Spanish. He speaks some Spanish. So he communicated to both Daniel and myself that he was not able to say with any certainty what the conversation
All right.
contained.
So state, I understand that there may potentially be charges against this person for perhaps presenting himself as an attorney. But if you could let the detective know that they're not to review those tapes as they relate to this case. Any detective who's involved in this case or officer who is involved in the case out of this court is not to review those.
Okay.
That it will be sent to me and I will review those and do in camera.
Does that include members of the district attorney's office?
Oh, you were not here for that discussion. The district attorney's office is not going to be reviewing that. I will review it. And if either party says, you're my attorney, or this person presents himself or has presented himself as the attorney for your client or Ms. Compton's client, that's all I'm going to listen to. And then I will let you all know that he presented himself as an attorney. Then the next question is going to be whether that's enough to establish attorney-client privilege when in fact this person is alleged not to be an attorney.
And if it turns out that that you don't find anything like that, then I'm assuming at that point it'll be released to everyone.
Yes.
Okay, sounds good to me.
And Judge, I found the detective, his email in my address book. I was just gonna send him an email.
All right,
Pretty
thank
much
you.
All of us.
Yes.
including you, Judge.
Thank you. So, Mr. Leal, that's the court's proposal. Ms. Compton is in agreement with that. Are you in agreement with that?
Yes, Your Honor.
All right, so my understanding is that they already have the videos. So let me see what date we can bring this back. And state, when do you think you'll be able to have the videos to the court?
That I don't know, Judge. I think it's more just scheduling with our investigator to go pick them up.
All right. So what I'm going to do then is I'm going to recall this case. I know that spring break is, I guess, the week of March 11th or the week of March 18th. Am I correct? Who has school-age children? All right, so we're going to recall this for March 4th. And on that date, that state March 4th, is that enough time for it to be given to me?
Yes, sir.
All right, so March 4th, just so everybody is clear, the only thing is going to happen on that date is you all going to come in. Why were you late for court?
I was, sorry, I was walking over from the parking.
All right, you just never seem to time things well.
I was trying to get close to parking spot today,
Yes,
so.
but you had all day to get a close parking space. You know what? If you're going to be late in life, you're going to miss out on things. You understand? Because you were late today, you know what I could do? Have the deputy take you into custody and take you to jail. And then you know what happened with your vehicle? Your vehicle would probably be towed wherever it is. You understand? Do not be late in your life, not just for court, but for anything, because people are depending on you to show up on time when you say you're going to be on time. You understand? All right. The state has filed a dismissal in your case. I don't know anything about your case other than what the charges are. You may be excited. You may want to celebrate. Do not do that. Sit and think about how you came to be in the 187 District Court and just don't come back again unless you're coming back to visit. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
You're welcome. I'm going to give you all a reset. The reason why I'm giving you all the reset is because of the new case. And state if you'll make sure that they have the discovery on the new case.
Yes, Judge.
And when I say new, it's new in the sense that I think you all have only had 3 settings on it. And that's the case involving a security officer.
That's correct, Your Honor.
And I don't know if anyone was planning, because I think this may be a case that was previously tried in this court.
It was a different case, co-defendant in that case, Your Honor.
And I don't know if anyone has requested the transcripts from that or received that. Does anyone know?
I don't,
The
I'm not
state
sure.
does not. I don't know.
I'll ask Ms. Shaughnessy, but I don't think so. We've reviewed the cases several times and we haven't looked at anything like that, so.
So I don't know if,
Oh, we did.
okay,
I didn't know that, Judge. Sorry.
all right.
Is it ready?
All right, so my understanding is that you all have the transcripts. So what I'm going to do is I'm going to reset this and I'm going to give you all a short turnaround. And that turnaround is so you all can discover what is a good jury date.
Yes, Judge.
State, I know you have some murder cases upcoming.
Yes, Judge.
Let me see. All right, there's a special setting on Bordeaux. And Judge Jarrett is actually handling that case because I can't handle it because I knew the complainant and all the judges knew the complainant. So I'm going to set this on the 26th. However, there's going to be a conference room that is going to be reserved for me if Judge Jarrett is going to actually be in this court and can't be somewhere else. And then that's where we'll meet.
February 26th.
And
Yes.
Judge, just that the court be aware of defense. I'm going to be on that Pardo murder, so I will be in trial. I don't know if that causes.
That changes things because you need to know what date is good. All right, are you all okay to do this by the 20th then? Is that enough time for you all to figure out
Yes.
when?
I think so, Judge. I can get an answer for that from administration and stuff.
All right, and are you employed?
Yes, ma'am.
What is your work schedule?
I'll be here.
No,
Oh,
I mean,
I work overnight. I work 6 days a week, 12 hours, 6 to 6.
okay, because if you were going to be at work or you needed to be at work, I was going to allow you to appear by Zoom. All right.
Feels always right. Spicer better have a good excuse. if she
Told you,
asks for it. I'm like,
you're in trial.
really?
Hello. Deputy Laura, I see that there is a long line downstairs. Good morning. All right, everyone, I'm going to call the docket. When I call the docket, you need to stand and let me know you're here. If you don't answer, I'm going to assume you're not here and a warrant may be issued for your arrest. And there will be a trial today, so someone's going to trial. Deputy Laura, the court reporter asked me, she said, are we doing trial? I'm like, this is the 187th. Of course we're doing trial. All right, Anthony Perkins, custody. Tamika Studemeyer. Thank you. I'm going to get your name right one time, I promise. Amy Oliveras. Thank you. Mario Vargas. That's supposed to be by Zoom, I think. Clinton Camacho. Clinton Camacho. Abel Favala, custody. Nicholas Ramirez, Alexander Rodriguez, Nathan Martinez, Richard Casanova, Byron Agee, custody. John Jacob Galvan, John Jacob Galvan. Omaro Sanchez, Janet Silva, Rakeem Asmore, custody. Jenna Davila, Jenna Elizabeth Davila, Sable Cassiano, Ayana Hubbard, Leslie Ayala, custody. Christy Brown, Christy Leslie Brown, Joseph Kruger, custody. Mark Ivy is in federal custody. We'll see what's happening with that. Philip Harris, Philip Kendall Harris, Joe Jimenez, custody. Juan Manuel Clara Rascon, Tamar McIntyre. Why is that on the docket? Well, was he brought over? All right, thank you. Marco Marino Vasquez, Edgar Aguilar, custody. Sarah Gutierrez, Samantha Ann Malik, or Malik. Nathan Martinez, custody. Darren Johnson, hi. Thank you. Good morning. Jose Amador, custody. Larry Smith, custody. Zayden Ali, Zayden O. Ali. Brenda Sanchez Carpenter. Miguel Aguilera.
Yeah, she's in the hospital, if I could approach her without.
All right, yes. Jesse Vega, custody. Jeremiah Miller. Thank you. Kevin Wright, custody. Raul Juarez, Anthony Davis, custody. Alfredo Garza, Timothy Johnson, Daryl Payne, custody. Is there anyone who came in late or your name was not called? Yes, what's your name?
Your Honor, John Galvan.
John Galvan. All right, thank you. All right, thank you. Yes,
Your Honor, Eloy Gonzalez.
I'm sorry, who? Eloy Gonzalez. All right, just give us a moment and we'll call you up, all right? All right, attorneys, you all know the rules. Please follow the rules. You're not ready to approach the court if you have not conferred with your client and conferred with the state. And yes, if your client is in custody and need to be brought out, once you requested your client from custody, do not leave the courtroom. Excuse me, what's your name? Are you on the docket?
I'm good to, watch it try it.
Oh, okay. All right. Just have a seat. All right. Please confirm.
Not in the first row, ma'am. Not in the first row.
All right, Deputy Laura, the Wellness Center, they're having the 12 days of fitness. So you can win HEB gift cards and the challenge begins today. Oh, we need to enter that. Excuse me, sir, what's your name? You're in the maroon sweatshirt.
Name? The first row, sir. Is it for you? What's it for? Is it for you?
Oh, no, it's supposed to be looking at it.
Yeah. No.
Probably, the first year, January, nobody on that. It's kind of a weird thing, it's something. Yeah, I just. Great, like that's us. I saw it was separate. I have the Bible. Alright. Okay, it's so here's 727 283. You have a card now? Where's it? Sure. How much? Oh, let's try 77282. Thank you so much.
I'm sorry, who's not a part?
No, Miguel.
Okay, awesome.
It was towards the end of the docket. Go to case number. Miguel, I'm gonna get. Resolution. The judge said. Is he rejecting the conditions?
All right, Miguel Aguilar.
Good morning.
Aguilera, yes.
Yes, Judge, Mr. Aguilera's been in the hospital since November 20th, 2024. Last time we were here, he just had surgery on his leg to remove a bone.
Mhm.
There was appears to have been some complications, and he's been there since the 20th.
All right. All right, is there any idea of release or no?
There isn't, Judge.
Okay.
He was in a wheelchair last time, but he's had some.
Counsel, do you have any?
Documentation. She told us this morning, we asked her to provide that documentation as soon as she can. I could try to get that to the court as soon as possible, but that's the status of her at this point in time.
All right, Mr. Garahan,
Yes, Judge.
on this case, you know, he says his client is at the hospital with issues pertaining to cancer treatment.
Okay.
But he doesn't have any documentation.
I mean, the state's position would be asking for a bond forfeiture or a judge's warrant. And if information comes forward, obviously we would defer to the court.
All right, so what I'm gonna do, if there's no objections, because it's driving while intoxicated with a child under 15, I will give her till 1:30 to get that documentation to you. I think that's fair.
Yes, ma'am.
Yes, Your Honor.
I'll provide that to the court as soon as possible.
All right, thank you.
Thank you, Judge.
Brian Perkins. All right, D'Anthony Bernard Perkins. Thank you. All right, so before we go on the record, and Jason, this is a motion to reinstate bond.
Yes, Judge.
Okay, first thing, the bondsman.
I reached him. They'll only do it if he can pay 2,500 as soon as he gets out. If he can't do it,
Okay, so then,
we would just ask if the court would set a bond at somewhere around the original bond. It was 30.
all right, and have you conferred with the state?
I have with the state.
Make it go. Let me just. No agreement, Your Honor. I think at this point, they confer, but no agreement.
All right, we'll go on the record. The court is calling CM 1192 5-4 State versus DeAnthony Perkins. Can I have parties announced for the record for the state,
Jason Garahan, Your Honor.
for the defense?
Albert Chidas for Mr. Perkins.
And are you Mr. Perkins?
No.
All right, we're here. Defense, you filed a motion to reinstate bond. The court, of course, informed you that the court could not reinstate the bond unless the bondsman wanted to be placed back on the bond. And can you tell the court for the record what the bondsman is willing to do? Are they willing to have the bond reinstated?
They are willing to go back on the bond, Judge, but only on the condition that my client make a payment of $2,500. I've told my client cannot make that kind of payment, today or the next day.
Mhm.
So we would have to go with a different bond company and just start over again. So we would ask the court to consider not reinstating the original bond, but setting a bond at the same rate as the court had set the bond originally, which was $30,000.
All right, so according to your motion, and of course, this is public record, Mr. Perkins, so even though he put it in his motion, the court would have known and the state would have known. A violation report was entered for your failure to appear at a county court at law number 7. And as we know, county court at law number 7, those are alleged to be assault cases. Is that correct or not?
That is correct, Judge.
All right. So you're asking that his bond be set at $30,000?
That was the original, and we would ask for that. If the court's generous, we would take less.
State?
State's not opposed to a $30,000 bond, yeah.
All right, state, you may be excused. All right, Mr. Perkins, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand. So why did you not appear in county court at law number 7?
I wasn't able to go, so I had called the court the day before to tell them I wasn't going to make it, to try to reschedule it. And they gave me my lawyer number, and I called him and he didn't answer.
Well, I actually did talk to him, Judge, and I told him that there's no way that I can reset his case. So that do whatever we can to get down here, but he wasn't able to make it.
All right, so back to my question, why didn't you make it?
I didn't have a ride,
Why didn't you take the via bus?
have the funds.
All right. But it says in the motion that he wants to resume his employment. When's the last time you were employed?
Before I got arrested.
For the county court 7 violation?
Before that,
All right, give me a year.
last year,
All right. And do you live by yourself or you live with someone else?
my girlfriend,
All right, and is the girlfriend the same one from county court at 7 case?
no ma'am,
Different one, Judge.
All right. Do you have any children?
2,
What are their ages?
1, and I got to be born on the way.
All right. Have there been any drug history or drug use in your past?
No.
Any mental health issues?
No ma'am,
Have you ever been diagnosed with any type of mental health issues?
no ma'am.
Have you ever been on any type of medication?
Adderall,
Right, and what are you taking Adderall for?
my ADHD,
And do you have a support system? And who's your support system?
my girlfriend,
All right, I'll set the bond at 30,000. I'll do regular UAs. Waive fees. And who is the complainant in the county court 7 case?
It's actually been dismissed, but it's a Demory Price,
How do you spell the first name?
Domory.
said D,
B.
D, Demery,
Demory Price.
All right, let's spell that again.
DEMORY,
D.
EMORY.
All right, there should be no contact with Demery Price. And we'll get ahead of the game. I'm gonna order parenting classes, but I'm gonna waive the fees. All right. Is there anything else?
No, Your Honor.
All right, so we can go off the record. What will end up happening is because this case has not been indicted, you won't have a court date with us until you're indicted or your attorney asks for a court date. Do you understand?
Yes, Your Honor.
All right, good luck to you. Make sure that you stay in contact with your bondsman.
Your Honor.
All right, thank you.
Thank you, Your Honor.
And see if they like it. The equipment is very expensive. I think the equipment is over $10,000, but there's such a desperate need for court reporters. I'm sure they will actually loan you a machine to practice on. And then you can always come to the 187th and practice.
Sounds good, Judge.
Who knows? I'll retire and come back as a court reporter. And then I can complain to you, Cindy, and say, they want their records.
Why is she laughing, Judge?
Yeah, I know.
Laughing.
You know, I tell everybody in Paris, oh, sir, you can have a seat. We're gonna wait for your phone. In Paris, at least when I went to court, no court reporters. Everything is recorded. How do we walk in the courtroom?
Okay.
And all of the deputies look like they stepped out of a GQ magazine.
So technically, you're doing Napoleonic law.
And I would tell you, it's something about a man in a beret. I don't know. But I will tell you, all of them look as though they stepped off a GQ runway. So I don't know who's designing their uniforms, but
Pretty awesome.
maybe it's Chanel,
Never know.
but it looks great. Well, they have revamped the Notre Dame. I need to go see it.
Oh, yeah, I heard about that. It's
It's-
opening back up.
From the photos, it looks as though it's lighter inside. It used to be very dark. So I hope they haven't changed anything and it's exactly the way it was, where you go in and you can
Rewired
barely see.
everything.
Yeah. So we should see.
T21, whatever it takes.
Yeah.
With your permission, I'm gonna run to a different court. And I'll
Yes.
check back with Deputy Laura, who'll have the phone in an hour.
Oh, well, I don't know if it's going to be in an hour, but they said they would get it here.
I'll check back.
All right, thank you.
All right, thank you, Judge.
All right, thanks. Jennifer Arzola. Hi.
Hi, how are you this
All right,
morning?
how's it going?
Good, good. This is just a quick request. This is set for Thursday. We'll resolve it on Thursday, but I was hoping to come on Wednesday
Sure.
instead. Is that okay?
All right, you'll be able to contact your client?
She's in custody,
Okay.
so hopefully y'all will contact my
Okay,
client
sure.
for me.
Norma, can you call Jennifer Arzola for Wednesday?
Awesome.
All right.
Thank you so
You're
much,
welcome.
Judge.
Have a good
I
one.
appreciate it. May I be excused?
Yes,
Okay,
thank you.
You know that Armenia also.
Raise the course.
Oh, wow.
I didn't realize she is doing it.
Oh, that is so awesome. Yeah, we have students who will come in sometime and they come in to just practice while you all do your thing and they talk to you. I think it's so awesome. Who knows where my career would have taken me if I would have decided to become a court reporter?
I was a hairdresser first, so
Oh my gosh.
yeah, for 13 years.
All right, Norma, that's that one if you have them brought up on Wednesday. Zayden Ali.
Right here.
Hi.
Morning, Judge.
Good morning.
I brought my water. Is that okay?
Oh, that's fine.
All right. Judge, I've just received the affidavit of surety's surrender on this case.
Mhm.
It's false. The
You
reason,
know, I will tell you, I issued a judge's warrant and remanded him without bond
okay,
because he wasn't here on time. Court starts at 9.
Judge, I'm sorry. I was in county court number 4. As I told Norma, I told him I was gonna be there first. We were gonna meet. When I went to county court 4, we just missed each other. I came up here. He's like, where are you? I was like, I'm in court. He ran up. I was in the bathroom. We came in together.
No, he's supposed to be here at 9. Why wasn't he here? That's the question.
Because I told him to meet me in CC4.
All right, well, that shouldn't have been done
Well,
because,
then, Judge, if you don't take him into custody, take me. I'm the one that told him.
oh no, he knows he's supposed to be here at 9.
But don't talk.
This is not the first time he's been late to this court. It's chronic where
Okay.
he's late.
Okay, Judge, we're set for trial.
Yes,
Defense is ready.
all right. Jury will be brought up.
Okay,
All right, thank you.
have a seat.
Well, she just. Anthony Davis. Oh, there you go. Oh. Then you get it. Good morning. Yes. For good reason.
Yes.
You said remanded without bond?
Yes.
Can we have a bond?
As soon as y'all file a motion, I'll hear it.
All right, I'll type something up.
Judge, this is just a pre-indictment. The intake attorney asked me to.
Thank you.
Yes. Sir. Thank you, Judge.
Hi, oh, come forward. And are you with Sanchez? Sanchez?
Yes.
Carpenter.
Oh, Carpenter, okay. Sanchez Carpenter.
Yes, Judge.
All right, Brenda Sanchez Carpenter, if you come up. All right, so defense counsel said that they're rejecting the offer, they're requesting a trial.
Yes,
How long do you expect the trial to last?
2 days.
All right, Norma, I need this on the docket.
Usually there's gonna be, I anticipate 3 to 4 days. There's some forensics, computer experts. I think it'll take a little longer than that.
All right, Norma, if you can set this, it's gonna be a 3-day trial. If you can set it for this month, please.
But we have something in January.
No, this case has been on the docket since August. All right, December 9th.
Your Honor, I have a motion to suppress that day. That's a full day motion to suppress.
All right. Well, we don't select jury till the 10th.
Okay, so it's just a call docket.
Yes.
Okay.
All right, and if you all can make sure you do an acknowledgement of discovery for me, please.
I've submitted one. I'm not sure if they've signed one.
Also, Your Honor, I believe the lead counsel, Freddie Bruce, is gonna be filing a motion today requesting the court appoint a forensic person to go through the forensic, so computer. It all derives from alleged computer things mailed or sent.
All right, so this is going to trial on December 9th is call docket and December 10th is jury trial. So I'll need you back here on December 9th. And if y'all do an acknowledgement of discovery, please.
If we could check the court's file, because I believe last setting I did, but would you mind to look in there and see?
This is what they're doing for the court's files now.
Oh, is it?
Just a
Okay.
sheet of paper.
If they're not.
I can check.
Right. I do have notation in October that all discovery was received though, so.
Yes, Your Honor. Violate condition number 4 in Bear County, Texas, the defendant Anthony Lee Davis did then and there fail to report to the supervision officer as directed for the months of June, July, and August 2024 in violation of condition number 4.
How do you plead to that? True or not true?
True. Your Honor, we'll waive the remaining violated conditions.
Any objection?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, and sentence you to 7 years in the prison and $1,000 fine? Knowing that, do you still wish to plead true to violation of condition number 4?
Yes.
Court will find violation of condition number 4 true. Is there a proposed agreement?
There is, Your Honor, and is to deny the motion, alter and amend for a return to state ISF and GPS with RMS upon release from state ISF. That's a lot of initials, Judge.
All right, thank you. All right, why should I follow this agreement? He hasn't reported.
I know, Your Honor. I think it's not an excuse, but he's homeless, and he has no telephone, and it's not an excuse, but he still knows that he has an obligation to report. And just the fact that he just doesn't have the ability to report in.
All right, this is his third motion to revoke.
I understand, Your Honor.
His previous motion to revoke was a violation of condition number 4, not reporting.
Yes, Your Honor.
Then he had another violation of 14U.
Yes, sir.
So I don't think there's anything that the court can do to help him. I don't think he's a good candidate for probation.
Your Honor, and probation has not given up on him. And I asked the court not to give up on him either. Probation still believes that if they return him to ISF, that can still help him. Otherwise, everybody, the state also believes, and I asked the court not to give up on it either.
I mean, he's been to ISF before. He's been to ISF cognitive. I did GPS partial. So he's had everything.
Can I have a chance to speak?
Sure. You want to raise your hand?
Yes, ma'am.
Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Anthony Davis.
All right, what would you like to say?
So that address that's on file, that was my friend's address that I was supposed to be probated with, but when I got out, I couldn't stay there. So I was homeless from day one and I relapsed on day one. Day one, I relapsed and I had nowhere to go, but now I do because.
Well, no. Let's backtrack a little bit. You were placed on probation June 28, 2022. And a lot of cases were taken in consideration. You were placed on probation for 7 years.
Yes, ma'am.
And there were some no contact of certain persons that was ordered by me. The court did a referral to felony drug court. If not accepted there, you were to be placed in lifetime recovery. And you were to remain in custody till transferred to lifetime recovery. You're to report by Zoom. I had the UA hotline. And then there was a motion to revoke filed on May 25th, 2023. I did another referral to felony drug court. Then on June 8, 2023, you were in Comal County. I think you were in the Comal County jail or somewhere. I'm sorry, defense counsel was in Comal County. So then we recalled it for June 12th and it was set for a contested hearing. And then we had June 13th and it was recalled for August 3rd for contested. And then you ended up entering a plea of true to violation of condition number 4, which is not reporting. And I know I told you, you need to report.
Yes, ma'am.
So what I did, I denied the motion, alternate amend conditions to GPS, full until further notice, the MIC evaluation, and pre-screening for mental health court. Then this case was recalled for January 30th, 2024. And then on January 31st, it was recalled and you entered a plea of true to violation of 14U. The state waived the other violations. I denied and altered and amended the conditions to include ISF cognitive and GPS partial. And now we're back here for a violation of condition number 4. So you know to report, you just don't report. And I don't think probation is a good fit for you.
Can I just, one more thing?
Sure.
right now is like I'm having a whole turning point. I'm working, I was doing my job and I got my mom behind me now. And she'll tell y'all that I can stay there now. And she wants me to come home and my family wants me to come home. I want to do the right thing. I promise you, I want to do the right thing. There's nothing more. The worst thing in the world is doing time when you have kids. And I understand that now. Like I do. I really want to.
No, I order parenting classes, so you should have understand that previously.
Yeah, Your Honor, if I
Yes.
may. Now, he has not completely not shown up, all right? He has shown up or he has reported. And the only one they're mentioning right now is the last 3 months, but he has reported prior and he has put an effort. And I ask the court again to not give up on him. Just give him another opportunity to go back to what probation believes would help him.
Last
And-
chance, you know.
And I ask the court to please do so.
All right. The court is going to grant the motion, revoke you. The court will sentence you to $1,000 fine, give time and money to run concurrent. Does anyone wish to speak to the 7 years? Because that's what he agreed to.
And Your Honor, if you are going to sentence him, then I ask that you give, reform the sentence and give him less than that.
All right. State.
I still defer to the court, Your Honor.
All right. The court is going to grant the motion, sentence you to $1,000 fine, time and money to run concurrent. The court will sentence you to 4 years in the prison, give you credit for any time served, and I'll give you credit for any successful ISF completion.
Thank you, Your Honor.
Right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? You have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on community supervision. Do you understand?
Yes.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. If he would like, I can have him placed in the therapeutic community since he states there's a drug or alcohol issue that's going on with him.
Yes.
All right, so with regard to the therapeutic community, I cannot force them to accept you into the program because I have no jurisdiction over the prison sentence system. But what I can tell you is that if you don't ask for it, they're not going to give it. If you do ask for it, they may give it. It doesn't increase the length of time that you're in custody for. According to the plea bargain agreement, the state is proceeding on count 1. Punishment is to be assessed at 5 years in the prison. There's no application for deferred adjudication. The state opposes your application for community supervision. There is an affirmative finding of family violence and no contact with the complainant. Have both parties had a chance to review the PSI report? State?
Yes, Your Honor.
Defense?
Yes, Your Honor.
Any objections? State?
No objection.
Defense?
Just the statements from the complainant. I don't believe she's coming today.
All right. Is the complainant present?
No, Your Honor.
All right. And then have both parties had a chance to review the TAP evaluation?
Yes, Your Honor.
Yes, Your Honor.
Any objections to the TAP evaluation?
No, Your Honor.
No, Your Honor.
All right. State you're opposed.
Yes, Your Honor.
And why are you opposed?
Your Honor, we're opposed because he has already been on probation for other offenses. He has exhibited the same behaviors over and over again. He's had multiple chances to turn his behavior around and has not done so. He was also on probation at the time of the offense. And reviewing the PSI officer states that he does not take responsibility for his actions at this time, and he is not motivated for treatment.
May I respond, Judge?
Yes.
Regarding the lack of accountability and taking responsibility, I discussed that briefly in the memorandum. His recollection of that night is virtually non-existent. It's been pieced together from bits and pieces he remembers before the drinking, evidence review, discussions with me over several months. He's already taken kind of like an upfront jail sanction. He's been in custody on this case for 230 days at this point. And I do believe that a lot of that confusion in the taking responsibility is because he can't give a perfect recitation of the facts. He can clear up some of the discrepancies, but a lot of that he's not able to say whether how exactly the striking happened to cause this offense, Judge.
All right, so here's the court's question. The court has read your memorandum. The state had no objections to the court reviewing that. So was he passed out to the point of intoxication? And was there medical intervention due to the intoxication? Does anyone know?
Yes, so he progressively got more intoxicated as he's sitting there with the officers, but it did quickly reach that point in his blood where he was passed out, woke up in the hospital. There was intervention at the hospital.
All right. So defense, do you have any witnesses?
Just Mr. Waters.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Raul V. Juarez Jr., Your Honor.
All right, you may proceed.
Mr. Waters, you wanted to take responsibility for what happened on March 25th, correct?
That is correct, sir.
And you understand that while you don't remember everything, you are admitting and accepting that you did harm with the others.
Yes, I did.
And you want this judge to give you probation, not because you just want another chance, but because you've never been helped. You've never gotten a serious treatment for your alcoholism. Isn't that right?
That is correct. I've never had any type of a treatment related to alcohol.
You had a serious crash, which is part of a DWI years ago. Do you remember what year that was?
That was in 2001.
And that was a serious accident, wasn't it?
Yes, I should have lost my life during that accident.
And you should have lost your life this night.
That is correct. My heart rate was to the point where the doctors didn't think I was going to make it when I woke up in the hospital.
And you understand that voluntary intoxication doesn't excuse all of your actions, right?
That is correct.
That you still committed them, correct?
Yes, correct.
But you would like to become a productive member of society, right?
Correct.
You'd like to continue to work.
Correct. Correct.
You'd like to continue to see your family.
Correct.
You'd like to see your granddaughter grow up.
Definitely grow up, yes.
But you realize that you're a different person when you drink.
That is correct.
You were doing, you had complied with your probation that you're currently still on, up to the point of the offense date.
That is correct. I did complete a BIP class. I reported to every assignment I was reported to. I did the UAs. I did everything that the court was requesting. And,
Who is the complainant in cause number 2021 CR 8180?
It's the same complainant, Judge.
Right, so let's get to the crux of the issue. The last time we were here on the 2021 CR 8180 case, I had ordered no contact with Carmen Gutierrez. And that motion, there was a motion to a probation violation, and it was withdrawn. The state stated they could not prove the new number one. And the defendant said that the complainant continued to contact him. And now I've read in the stipulations, and in the stipulations, or either in the report, it states that the defendant is stating that when he was released from custody, the complainant had moved all of his things to her home. So that's someone different.
That's someone different. That's
okay.
Jessica, his more recent girlfriend.
Okay.
She had moved things to his home, but the relationship with the complainant in this case was a toxic one, where even after the no contact order and the case that he was on probation on, they ended up, reuniting and having contact on the date in question.
So I'm trying to get to the crux of things. The court ordered him to have no contact with her. He decided to have contact with her. Whether she wanted to have contact with him or not, or whether she was coming by his house or not, he decided to have contact with her. Is that correct?
That's correct, Your Honor.
And he went to her place.
No, sir. No, ma'am. It was my place.
All right, so it's your home?
Yes, ma'am.
Are you on the lease and she's not on the lease?
I'm on the lease, not she. She was living in San Angelo, Texas at the time of the offense, ma'am.
And so she's not on the lease.
She's not on my lease.
State? Any information in regards to that?
I have just a few minutes.
Sure. And the new number one in that motion to revoke, was that this case?
No, that was a violation of protective order that they were going to file, but they could not prove it, so they did not file it.
Okay.
And it was a separate, like, I believe it was digital communications that they were gonna go after. And then they didn't file the one for this, a separate case based on just them being present, because they realized that she had wanted to be with him and that out of fairness, they would proceed on the assault rather than the violation of protective order when it was consensual contact, even though he had his conditions.
All right, off the record for a moment. Who is here on Silva? All right, if you'll come forward, please. If you all could step to the side a moment. Date in February for Silva, and it'll just be a date to see where we are.
Great.
All right, February 27th. Thank you.
Could I have that sheet back, or I'll get
Yes.
one for the file?
Sure.
Thank you.
All right, we all come back. Sorry about that. They didn't tell us from the jail.
We don't have any information as to whether she was on the lease or not at that time.
Okay. All right, we're back on the record. Any other questions for your client?
You're sorry.
Yes.
And you want to prove to your family, to her, even though you're never gonna have contact with her again, and the support that you're gonna become a better man, right?
That is correct. I'm done with alcohol. I gave my life, ever since March, I've drawn close to God. And I just surrendered with a white flag. I gave my life to him, and to take those things away from me permanently. I realized it's harming not only myself to the point where it's actually killing me, but also hurting my family. And I do want to live long enough. At 55 years old, I don't have that much time left. But I'd like to spend the rest of my what I do have watching my granddaughter, my only grandchild, grow up. And that's my wish, and also to retire in Corpus Christi, Texas. Somewhere down the line, I'd like to move my probation toward New Essex County, Corpus Christi, Texas, to be with my daughters and my new grandchild.
Nothing further, Judge.
All right, any further questions?
Just briefly, Your Honor. Mr. Juarez, have you been on probation before?
Yes, I have.
How many times have you been on probation?
Twice.
And were they successful?
Yes. The first one, yes.
And the second one?
The second one is this one. This is the second one.
So on the date in question, you said that she came to your house. Is that correct?
Yes, that's correct.
And she was inside your house.
Yes.
Why did you allow her inside your house?
I was outside washing my vehicle. The front door was open and she took the opportunity to go inside the house.
So
That
she
fir-
just ran inside the house.
She didn't run, she just walked in.
Did you call the police?
No, ma'am.
Why not?
She wanted to talk. So I gave her the opportunity.
But you knew that there was a no contact order
That is correct, ma'am.
and you still spoke to her.
Yes, to provide peace.
So you did not follow the conditions that the court imposed on you,
Neither did she.
but you did not
No.
follow. What do you mean by that? Neither did she.
Well, she was the one that placed that protective order against me and we both had an agreement that no contact according to Your Honor, the judge, Ms. Stephanie Boyd, and I agreed to my end. I remember Ms. Boyd, you asked me, do I have any possession that she owns? I said, no, there's nothing that she has that is of mine. So there was no need for me to even go to near her. But I don't like making enemies. I
Okay,
just
sure.
want to remain friends.
Mr. Juarez,
Yes.
that was a yes or no?
Can you repeat that question? Sorry.
Okay, so you said she placed a protective order on you. Is that correct?
Yes,
Okay. But you knew that you were not to have contact with her
yes,
and you still spoke to her
yes.
and you did not call the police when she came to your house.
No. My phone was inside the house at the time.
And would you agree that the first step is to accept responsibility for your actions?
Everything that happened on that day
Mr.
is
Rodriguez,
is my responsibility. It's my house and it's my, I take fault for everything that happened.
But did you tell that to the probation officer?
Yes. That it was my fault.
And would it surprise you that in the PSI, the PSI investigator stated that you were not taking responsibility for your actions?
There were some parts that I don't remember, but I take full responsibility.
So you admit that you punched her?
The complainant says that I punched her, then if I was going in and out of consciousness, then it must have been true. I'm not saying that I did or didn't, I don't remember. But I'm going with what she says. But I take full responsibility, my actions that night.
We pass away, Mr. Ryan.
No further questions, Judge.
All right. So this is what the court wants to know. These are the questions that need to be answered for me in order for me to make a decision on whether or not I'm going to grant his probation or whether or not I'm going to sentence him and what I will sentence him to. I want to know if the complainant went over to his home. That's what I want to know. So if the complainant wants to come in and testify, if the complainant wants to testify by Zoom, the complainant can testify by Zoom. We can go off the record. So here's the court's problem. I ordered no contact order, and I understand the circle of violence. I think everybody understands the circle of violence. But if you have the complainant going to his home and he's at his house minding his business, that's what he's telling me his story is. And the complainant comes to his house and he's extremely intoxicated. Obviously, he's extremely intoxicated because they had to take him to the hospital. In the defense memorandum, I see the photos where he's passed out. So I understand that. I'm taking that in consideration. I understand that intoxication is not a defense, but I'm looking at all factors. So what I want to know is, did she come to his house? Did they decide to violate the court's rules, at least you, where I said you were not to have contact with her? Now, if I said you're not to have contact with her, which I did,
yes, you did,
and you let her move into your home, then that's neither here nor there. But if I have a complainant who's showing up to his house unannounced, even though the court has orders in place for him to have no contact, then that's something for me to consider.
Your Honor, in the police report, she says that they are living together, and when they took down her address, it was the same address as the defendant.
Okay. So does anyone want to see if the complainant wants to appear by Zoom?
If there's no objections, we can reach out.
Is it the old address?
Excuse me.
I'm sorry.
Judge, I think those might be two different addresses.
Yes.
Well, no. Here's my question. This is my only question. Any objection to the complainant appearing by Zoom?
I do, Judge. I would like to cross-examine her in person.
All right. So what I can tell y'all, either complainant will be here or not be here. If the complainant is not here, then I'm gonna go on what I have.
Can we have a 5-minute recess to reach out to the complainant to see if she's willing to come in and
This courtroom session starts off routine, but the judge quickly establishes control as cases begin moving fast. One defendant doesn't show up after already being given a chance, and without hesitation, the judge orders consequences, making it clear that court is not something you can ignore. Then another defendant walks in late trying to explain, but the judge shuts it down instantly, warning that being late can land you in jail and cost you everything, even your car. The tone is firm, direct, and unapologetic. Even when cases are dismissed, the judge doesn't let people walk away celebrating. Instead, she gives a serious warning to reflect on their actions and never come back to court again. In just a few moments, the message becomes clear. This isn't just a process, it's accountability, and every decision has consequences.